This isn't about some, just wanting to smoke marijuana. This is people who have been approved by their doctors for a medical purpose, and the evidence that I've seen and the stories that I've read is just overwhelming the help that many, many people derive from using cannabis as medicine.
Okay, welcome back to another edition of Cannabis in Canada with Jason Wilcox. I'm sitting here with Astound attorney John W. Conroy, QC, to speak about literally the constitutional challenge that we've got going on, the appeals, across appeals, and quite literally the recent decision with the extractions. So let's just start off here. We're just going to kind of get into this, if that's good, good with you, John. But R versus Smith. So in this decision, does this mean that we need, if not appealed, what does this mean for the coalition in respect to us not needing to argue the science behind R versus Smith?
No, we still have to introduce evidence, and we have to remember that we're in federal court, so it would bind the country. Smith is still BC courts, and even though the BC Court of Appeal is highly persuasive to judges and lawyers in other provinces, it's not binding. The decision of the BC Court of Appeal is binding on all lower courts in BC, so BC Supreme Court and the provincial courts are bound by it. But it doesn't bind the federal court. But it's good. We've got a BC Court of Appeal decision upholding that the limitation to dried marijuana was too restrictive. And a point in the decision which I think will help us, hopefully, on the appeal, is that, if you recall, in Parker, the trial judge ordered an exemption for Mr. Parker. And the Court of Appeal said, no, you don't legislate, you don't tinker, you strike down the law and you let the government figure out how to fix it up and make it constitutional. That's what led to the MMAR. So in Smith, the judge below at trial struck out the word dried marijuana, thinking that that would fix everything. Again, he was legislating. And so what the Court of Appeal did is they said, we're upholding your decision, but that was wrong. And they said, you strike down the legislation and has given the government a year to fix it up. It's a bit strange, given that the government has repealed the MMAR, and now they're given a year to fix it up in terms of the extracts question. But it's good for us, because that's what we say Judge Manson's error was on the injunction, was that he tried to legislate. He thought that by saying, okay, everybody who's got a valid permit the day I issue the order and on the day of the transition, September 30th, that would fix things. But as we know, a lot of people fell through the cracks. People who had permits the day before that expired, for example. So that's why we say he should have backdated it a year. That would have caught everybody. I just got the questions, or answers to the questions that we posed to the government in the discovery process. And in those answers, they show the statistics in terms of who was approved and what dates. And it looks like, excuse me, the great majority were covered by the injunction. But still a significant minority were not. And so hopefully then Smith, at least this part of Smith, as well as the overall decision in Smith, helps us to say, look, here's another decision of a higher court in British Columbia that not only upholds that the limitation on extracts is was too restrictive, but also that the way you deal with these things is you don't legislate, you toss the ball back to the government. So hopefully the Court of Appeal, Federal Court of Appeal, will be persuaded.
On that note,
another interesting thing, though, about Smith is that the dissenting judge found that while you were limited to producing and possessing dried marijuana, that it didn't limit you as to what you converted into before you ingest it, because it talks about oral or inhalation. So his view was you could always use extracts and stuff anyway. So that was kind of an interesting little point there in the 2-to-1 split.
Yeah.
So, yeah, Smith's a great decision from our point of view, and it's supportive for us. They accepted the evidence that was tendered there, and we have essentially the same evidence. Although there are a couple of additional experts that I've been talking to and looking into that we may call that are stronger maybe on the juicing or other strain type issues. So we'll see how that goes.
Excellent. Well, it's definitely a huge win, for sure.
Definitely.
Yeah. The next part, now we get a lot of people right now know, I know the answer to this, so this may seem rhetorical between us, but Section 53, patients are getting confused and out there who had MMAR and fall outside the injunction. And they believe
so their permits expired the day before or something.
Or something, yeah. They fall outside the injunction, but they believe that the Section 53 protects their gardens, and I'm trying to explain to them that it doesn't. And just for clarification, can you please explain what
Section 53 is? Yeah, I thought we posted this on the webpage, so people should go back and read it. And Section 53 itself, if it's not set out on the webpage, which I thought it was, it's certainly set out in the opinion that I first expressed to the BC Compassion Club almost 20 years ago in terms of the basis for their existence, which was long before the MMAR. All that Regulation 53, and it's a regulation pursuant to the old Narcotic Control Act that's been carried forward under Controlled Drugs and Substances Act, and it's the section that authorizes practitioners, which includes doctors and others, to prescribe any narcotic to a patient for a medical condition that they're treating them for. So when doctors are prescribing things generally, that's the legal basis for their ability to prescribe. It's not limited to prescribing. It's prescribe, administer, authorize, I forget the exact terminology. But so our point simply was that if your authorization to possess, your ATP, expired before March 21, you didn't have a possession license. You might have still had a personal production license from September 30th, but you no longer had a possession license. And you have to have a possession license. So we said, go to your doctor, take him your ATP, your authorizations, your applications, whatever under the MMAR, and ask him to give you an authorization under Regulation 53. You can call it a prescription, you can call it whatever you want. Some doctors don't like the word prescription because to them prescription means triplicates and filings and so on. The word prescription means a lot more to doctors than the plain simple English meaning of the word, which is to say you need this medicine for this particular condition, or we're prescribing it. So that's all. It only covers possession. It does not cover production. Sure, it would cover possession, I suppose, of a part of their garden, but it's only going to be up to 150 grams, remember. The court imposed that limitation as well.
No, that was also legislation, so
yeah,
I think the court legislated
exactly. It's a classic example of it.
Yeah.
And again, in the answers to the discovery questions, it shows that we have, I think, is about 89 people with 150 gram a day licenses. So presumably each one of them is housebound.
Yeah.
So.
Yeah, exactly. Now, the border. As we know, the border has become a big issue, in part because of the privacy breach that, of course, has now been certified and is going forward. More and more patients are needing to cross the border, are being concerned about what to say to a border agent when confronted with that ever question of medical marijuana. Even though we have all this legalization, what would your suggestion be to medical patients who are protected under the injunction or have an MMPR permit when it comes to crossing the border and answering that question?
Well, so you're being told that border guards, U.S. border guards, are asking a question about medical marijuana or marijuana generally?
In that scenario, yes.
Well, the law generally, as I understand it, and this is U.S. law, is that the guy in uniform at the border has a huge discretion. And they won't sort of pre-tell them what to do. And if you say anything about marijuana, if you've had anything to do with marijuana, they have a discretion to prevent you from going in. And so they don't need a conviction. They don't need a stay of proceedings, or even a finding of not guilty. They might say, oh, you've been involved with cannabis, and not let you in. Remember, this is Homeland Security. These are federal officials, not Washington state officials if you're talking about entering at Washington state. So it's a tough question because the worst thing you can do is to not tell the truth to a customs officer. Often the officer will have on his screen or information about you just from checking your license plate. May not if you're a passenger or whatever, but who knows? And so, you know, the questions sometimes are deliberate because they know something. And if you don't tell them the truth, you're definitely not going to be allowed in, and that's going to cause problems in the future as well. So the only thing I can say is that if you are asked, are you going to smoke marijuana when you're in Washington state, simply because of all the publicity about it being legal down there, I think the answer is, well, you know, if it's legal down there, I might, or I will, or whatever. The truth is, if you've got a medical marijuana permit, and again, I think the answer has to be, well, officer, I am authorized in Canada, and you know, it's only valid in Canada, and I can't take it into the United States, and I can't take any medicine with me into the United States. So I'm hoping that if I need to medicate, that there will be some reciprocal way of doing it. I mean, that has to be the truth. You know, preferably they don't ask the question and you don't have to even raise it. But if they do, I think that's the only honest answer to give. Certainly if you say I decline to answer, my assumption is they'll say, well, forget it. You know, this isn't a criminal investigation. This is simply to determine whether we're going to admit you into the country.
Okay. Excellent. Well, that clears up a lot in that respect. Now, you and I have talked in detail about the appeal and the cross appeal. For our listeners, we're heading into an appeal. Now, a lot of people have never heard of a cross appeal, so let's start with the appeal.
Okay. The judge grants the injunction. The government doesn't like it, thinks that there's errors of law, that the judge made errors of law in granting the injunction. So they file their appeal wanting to set it aside. We looked at it and we said, unfortunately, it hasn't covered everybody. People have fallen through the cracks. Therefore, we too are unhappy with parts of the injunction, the omissions. And so we cross-appeal to try and fix those gaps, to try and make sure that it does cover everybody pending trial. And so they file the appeal. They do a written argument in terms of their thing. We had filed the cross-appeal, and so in our memo of argument, we not only address their appeal, but we make our argument on the cross-appeal, and then they file a response to that.
Wow.
Okay? But it all gets heard at the same time, and we thought it would take a couple of days, because we're also bringing a motion to adduce new evidence before the Court of Appeal. We will say that, look, there's all these things that have happened since the injunction. We obviously couldn't put that in front of you before the injunction. It's because of the injunction. All the people who've fallen through the cracks, and a bit of an update on what's going on with all the licensed producers. And so we want to try and get that evidence before the court, so the court sees the problems, sees the potential problems in terms of supply, and problems with the LPs in terms of patients getting their medicine, so that the court's fully apprised of what's going on. Not only continues the injunction, the hearing is set, they've said they're only giving us 4 hours on I think it's November 26th or November 27th.
So that's the official appeal date?
At the moment, that's what they've said.
Is that
which is
proposed?
quite late in the day, given that the trial is in February. But that's, yes, it's in late November in any event is what they proposed. Once I have it firm, I'll send out a note to everybody so that you'll have that. But that's essentially the situation. So we will, they will get up and make their arguments, and then we'll get up and refute their arguments and make our arguments, and they'll reply to our cross-appeal, and then the court will presumably reserve and make a decision that you know, really will only have the effect of December and January and February, or at least until there's a ruling from the court.
I know we want to stay within the parameters of procedural and not hypothesis in law, but how comfortable are we as a collective moving forward into this appeal that, again, we can't guess, but how comfortable do you feel going into this appeal and cross-appeal that at least patients, at the very worst, will potentially likely end up just back with the injunction we have, and at best?
Well, I'm hopeful, and I think we have a good case, and so, you know, I'd be surprised if the Court of Appeal set aside Justice Manson's ruling, and hopefully we will persuade them that he erred in trying to fix it. He meant well, but he unfortunately didn't cover everybody, and there are all of these people that have fallen through the cracks, and that they are still medically approved people under Parker, which said you're entitled to reasonable access. And the government's way of providing reasonable access initially was, well, after Section 56 was MMAR, and now it's MMPR. And we know that the MMPR is not covering all medically approved patients. It covers those who can afford, but we also know that there's been a lot of complaints and problems. So, you know, the issue is that the patient needs to have their medicine on a daily basis, and to be secure that they have their medicine on a daily basis. And it doesn't seem like that's occurring, and they haven't licensed hardly any more. There's been a bit of change, I understand, but there's no greater number of licensed producers since we got the injunction. And a number of them have no supply, or have had recalls and things like that. So it's puzzling what's going on if the intention was to create a thriving licensed producer market for all of the patients.
No, I have a question. This has been something for me personally that's always dug at me, is that when they moved marijuana in with tobacco under the MMPR, it's now in with controlled drugs and or controlled substances and tobacco.
Or just a division of Health Canada.
Division of Health Canada. But when they moved it in with tobacco, and then Canada still holds, as we learned in the federal injunction documents, that Canada holds no medical value for marijuana. Why are the doctors still gatekeepers to a drug that's in with tobacco?
Well, the doctors are gatekeepers because normally doctors decide what drugs you need for your particular condition. You know, we argue that there are others like naturopaths and doctors of traditional Chinese medicine and so on who are more knowledgeable in terms of herbal medicine, whole plant medicine. Health Canada seems to be on a bit of a propaganda thing, continuing to constantly say, well, it's not an approved drug, it's not an approved drug. That's a bit surprising because Sativex is approved, it's whole plant, and so you'd think that that isn't accurate, the minister's statements. That's the first point.
Yeah.
The second point is that approved drug, as I understand it, means it doesn't have a DIN number. So it can't be on the pharmacopoeia, basically, where you'd get some kind of provincial health insurance coverage. So it's not as if approved drug means it doesn't work or it doesn't help people from a medical point of view, but that's the terminology that they use. So you saw recently that Mr. Harper was hoping to have the Canadian Medical Association and College of Physicians and Surgeons and another group, I forget the third one, help and support his anti-marijuana stuff in the Health Canada thing. Although I heard that the Minister of Justice, Peter MacKay, came out with some suggestion that the Conservatives were still thinking of the traffic ticket situation. But in any event, I just thought there was a bit of an inconsistency there. My understanding is that some of these health bodies, medical association, supports legalization, but they don't want to be the gatekeepers. They take the position that they don't know anything about it and don't know what to do, and therefore don't know how to figure out the doses and stuff like that. And so it's the government that's made them the gatekeepers, and they're somewhat reluctantly gatekeepers. But you know, a lot of it, I think, is hangover from the stigma in relation to marijuana and these sorts of things. Doctors prescribe drugs that can kill people certainly to which they can become severely addicted on a regular basis. Drugs that have what they call LDs, lethal dose ratios, LD50s. And so that's the concern in terms of prescription and so on. Well, you know, many of them just looked up the blue book that set out what the pharmaceutical industry says are the effects and dosages and so on. Now with the internet, of course, they can turn in their chair and Google or whatever and get more information. So why don't they do that about cannabis? You know, there is a huge pile of information out there about cannabis, and as has been well documented by Paul Armentano, who's the research director for Normal USA, there's more studies done about cannabis than other drugs. The cohorts from the other drugs are way smaller than the cohorts that are used in cannabis tests. There are double-blind placebo-based studies that have been done through the FDA in the US. They're just not well known and not well disseminated. So you say, well, you know, it's willful blindness on the part of the doctors. Instead of getting out there and learning about it, so that you can help your patients, instead of just, you know, throwing up your hands. And if you just don't want to have anything to do with it, well, refer to one of the doctors who has been educating him or herself about it, because there are some of those around. And I read an article just this past weekend. One of the well-known founding researchers, Todd McAreera in the U.S., you know, was saying he couldn't believe that the medical schools throughout the country are not teaching doctors about the cannabinoid system. You know, the discoveries that doctors and experts have come up with in studying the endocannabinoid system show that it is a critical human part of our human health system. And you know, that we produce chemicals that are very similar to the chemicals coming from cannabis on a daily basis. We don't produce as large amounts, and so that's what cannabis does. It acts upon the receptor sites and increases the release of dopamine and so on. And so it's really odd, in my view, that the doctors are so reticent, so ignorant in not informing themselves about something that could help their patients. But they are the gatekeepers.
I was just going to say, I'd like to allude back to that for a second here. Now, the CMPA waiver form under the Medical Marijuana Access Division, or basically the CMPA, the Canadian Medical Protective Association, who insure the doctors, had a waiver under the old MMAR that exempted doctors from any liability. Now, that waiver, when the MMAR was repealed, my understanding is the CMPA also allowed that waiver to be repealed and not necessarily applicable to the MMPR. Would you constitute this as a potential barrier to access for patients?
No, I mean, I'm assuming maybe they didn't bother with the new releases because they haven't had a single case of anybody suing them or seeking to find them liable for anything, so what a waste of time. Yeah. Marijuana does not have a lethal dose, you know, so people are going to fall asleep before anything else happens to them if they take too much. So they just aren't the same concerns that exist for other drugs. And as I say, I haven't heard of anybody suing their doctor as a result of being prescribed cannabis and having some sort of problem with it. So, but you know, the doctor in his office could just have the patient sign a release. I mean, it's just not magic, you know. And it may be simply that now, maybe they're saying, and I'm speculating, that, well, if it's all going to be produced by a licensed producer under all of these requirements that are set out in the MMPR, and individuals won't be producing then, and the only way you're going to prove that you're lawfully in possession is the label on the package, then, you know, we're not as worried as we may have been if it was coming from any old source and not having to go through these testing and so on and so forth. I'm a doctor, and I've said you can use cannabis, and you've used it from some street source, and bingo, you end up with, you know, some problem from it. It's hard to press to figure out what even that might be coming from the street, but nevertheless, there's always that potential. People have to remember that it's one thing to grow something for yourself, food, cannabis, whatever it might be, or have somebody grow it for you. It's a whole other picture when you're selling it to the public, and especially if you're selling it and holding it out to be medicine. You have to expect that there will be significant rules and regulations if you're going to do that.
Absolutely. As we look forward into trial, now procedural-wise, hypothetically again, we win trial, where do we go from there?
If we win at trial, then hopefully what has happened is the government has been told that the MMPR are unconstitutional to the extent that, in particular, they take away home production or caregiver production, and these limitations on amounts. And so the government will be given, not long I hope, but given the length of time they've had to think about it, but a period of time to make the MMPR constitutional by providing for home production and caregiver production and straightening out the limitation issue in terms of possession and so on, as well as the dried marijuana limitation. So if we succeed on all or part of that, the next step is whether one or party or the other decides to appeal. Okay. And the appeal would be to the Federal Court of Appeal. You know, so, and then there's an appeal from the Federal Court of Appeal to the Supreme Court of Canada. So that's the potential. I would hope that we can get it resolved after trial and move forward, given the nature of the issue and the patient's situation, but you know, it's impossible to predict.
No, again, now in the hypothesis of a win, a constitutional victory, which means that if medical patients win a constitutional right to grow, not a regulatory option as we have now.
No, it doesn't mean that. You have to remember, Parker says, if you put a person who is medically approved, so you've got doctor's approval to use cannabis, it's not I want to use cannabis, and that was clarified in Murnaugh. If the doctor approves you, then you have the right of reasonable access. Remember, Parker said that in the absence of the exemption, you were forced to choose between your liberty and your health. Those are the constitutional rights that were impacted. So it's not that you have the constitutional right to do this. It's to avoid the violation of your constitutional right to liberty and the security of your person. Those are that's the constitutional right that are an issue. So you don't get a constitutional right to grow simply because you've been in that position. The right you get is a right of reasonable access to the medicine. And so the government the position was the absence of an exemption involves a violation of these medically approved people's Section 7 charter rights. So you have to fix that, government, and come up with a solution where their Section 7 charter rights are not violated. And the MMAR was the first effort to do so. And the MMPR is the second effort to do so. And so the question is, have they come up with a system where your Section 7 charter right to life, liberty, and the security of your person will not be violated, except in accordance with principles of fundamental justice, under the MMPR? Okay. And we say, you don't cover all medically approved patients. You know you don't cover all medically approved patients, at least the poor, the people who can't afford $5 to $12 a gram, or even $3 a gram. And it looks like your system isn't adequate to cover other patients as well, by virtue of the recalls and the seeds and other complaints or lack of product on the part of these very few LPs. So, you know, the bottom line is that the patient needs to be secure and safe in ensuring that they have their product, their medicine, and for some, they're happy to go and buy it in a store. But others have figured out over a considerable length of time how to do it for themselves inexpensively and how to do the strains of things that work for them. And how is an LP going to do that for them? An LP could certainly grow a room full of a certain strain, but can they grow a room full of 500 different strains? You know, I don't know the answer to some of those questions, but my assumption is that the LP could buy your strain or buy your seeds or whatever, but would be hard-pressed to be able to, on a bi-weekly or monthly or whatever it is basis, give you that strain while also trying to give 500 other people their strain. I don't think that can be done economically, but we'll see what they have to say.
Okay, well, I mean, now in closing, John, as we look moving forward, now we got the Liberals proposing legalization, again in the hypothesis that the coalition wins this, that we win this constitutional reasonable access, being our gardens, and then we legalize, or vice versa, we legalize first.
Yeah.
Would it not be fair to say that we're equal before and under the Constitution? So basically, if I could continue growing after we legalize, it'd be kind of hard to say that, I'm just trying to understand this, that the person that's legal under a legalization platform, for the government to say they can't grow.
Yeah, no, you know, legalization, you gotta again define what you mean. We mean it's legal and it's no longer illegal. But, you know, Washington State, for example, it's legal. But it's only legal to possess 30 grams. So you possess 31 grams is illegal. So, you know, again, there's all sorts of rules that come in with whatever the legality is. So that's the first thing, is you have to make sure that you are legal.
Yeah.
And so it'll be interesting to see what they come up with in terms of production in home gardens. I would think that if a plant is legal to grow, you would be able to grow it anywhere, like any other plant,
Yeah.
especially if it's no longer illegal. But I would also expect that, given the history, that the municipalities anyway will come up with all kinds of rules and regulations about doing it in your own home or in an outbuilding or in particular zones. So one must expect that legalization does not mean anarchy. It means, even though I'm told that's what's going on in Washington State, is a bit of the Wild West still, and to some extent in Colorado because of the excessive taxation, but so there are still black markets. But the idea of legalization is to get rid of the black market and have a reasonable system whereby you could grow a few plants to consume whatever way you want. Again, making sure you don't affect your neighbor or cause harm or risk of harm to others, just as a general principle. So that is my hope and expectation of what they mean by legalization. But I don't know that for sure, if that's what they're going to come up with. Certainly the Conservative government would try to come up with something more restrictive. But remember this, and there's a problem, a big fight going on in Washington State because of the whole medical. And in Colorado, I'm told there's no problem. People I spoke to just this past weekend said in Colorado it's legal. There's one source for medical or recreational. There's no differentiation. Washington State, there's a big fight mainly over the 5 nanogram DUI presumption, which would catch most medical patients, but also over other aspects of the bill, of their law. And it's puzzling and a little difficult to understand. They're saying that the government's trying to eliminate medical. But, you know, if it all blurs into one, fine. But this is what I would expect to see in Canada. If it becomes legal by the feds taking it out of Schedule 2 to the Controlled Drugs and Substances Act, so it's no longer being subjected to the criminal law power, federal criminal law power, then generally it would fall to the provinces under property and civil rights. That's why there's always been this issue of, can the feds pass non-criminal laws, like the, you know, out at the airport they have the they used to give tickets and things as federal sort of tickets and stuff, the Contraventions Act. And you'd sort of say, well, can the feds, you know, the feds' power is criminal law. The province's power is over property and civil rights and matters of a local nature in the province. So, you know, alcohol is regulated by the province. The feds will always have an interest in terms of import, export, anything affecting international boundaries. So you can expect there'll be federal and provincial laws in relation to legalization. But medical, in Canada, we have the natural health care products legislation, which is under the Food and Drug Act. And so I would expect that if you are growing and producing and intending to sell to the public your product, you will be controlled by the natural health care product regs, which aren't that different to the MMPR, except that they're not a controlled substance, so you don't have all the security and all the rest of it. But I think they took quite a bit from natural health care products when they designed, you know, the other parts of the MMPR. So that then puts us in this odd situation of, if you're going to sell to the public, you'll have to be federally licensed. If you're simply growing it for yourself and using it for medical purposes, you know, again, it's just for yourself. The minute you start selling it or holding it out to be medicine and selling it or even giving it to others, I expect there'll be some rules and regulations around that.
Right. Now, I guess, just to close out, the chances of Canada saying we're going to legalize where medical patients can grow, but if you're legal, you have to only buy it from Tweed or the corporate entities that exist now, the 20 licensed producers we talked about.
13.
Is that a possible scenario, given we're not like the U.S., we have Section 15, we are equal before and under the Charter?
You have to remember, Section 15 of the Charter isn't about people being equal. It's about equality before and under the law, and the equal protection and the equal benefit of the law. In other words, there's a law that authorizes or doesn't authorize something. We're all equal under that law. It doesn't mean we're all equal in terms of everybody having equal this and equal that. The reality is we're not. We're all quite unequal. But so I'm not sure if I understand. You know, if there was a law that said, or no law, so that it becomes legal to grow, then it would apply to everyone.
Yeah.
So I'm not sure where Section 15 comes in.
I'm saying right now we're arguing a constitutional challenge for 40,000 medical patients that we know of.
Yeah.
500,000 by Health Canada's estimates. So let's just say we win. So we win that reasonable access, a constitutional reasonable access being our gardens.
Yes.
Then they legalize and they say, but you guys can't grow. Is that not raising?
Well, how do you legalize and say you can't grow? That's
well, we got Washington did and Colorado did, where you can't.
Well,
grow.
no, you can grow up to 15 plants, and you can have 4 in one place, or 3 in one place, for a total of 45 in Washington State.
For the legalization for regular adults?
Medical.
No, I'm talking about regular adults. That's what I'm saying.
Yeah, no. The medical there allows up to 45 in one place and 15 per patient. Most of the U.S. medical statutes are 15 plants.
Yeah.
That's one of the things that's a bit bizarre about our MMAR. You know, they complain about the hundreds of plants that the patients are growing. Well, they came up with the formula. Where'd they get the formula from? And how come they didn't talk to the U.S. in terms of what's going on there? Because I'm told they don't have fire, mold, and public safety issues being put forward as a major thing. I mean, there may be a little bit, but not much. So, my expectation would be and again, I guess we'd have to wait and see, but if they legalize marijuana, how do you legalize marijuana generally and not allow people to grow it? I mean, it's like tobacco and making your own beer and wine, right? They could, theoretically. It would be subject, undoubtedly, to a number of court challenges. But it may be Colorado. It just seems odd that if you're able to legally possess it, and it's legal generally, then why would you not be able to grow it? Who would care?
Yeah.
I mean, you'd be subject to some restrictions maybe in terms of place and manner and things like that.
I think
Zoning.
maybe a better analogy would be, let's just take Washington State and put it in Canada. Now, would that be legal under Section 15 of the Charter? To divide medical and say they can grow, but the legal people can't, because they're just legal adults, they're not medical. Would this open up?
Well, I mean, if you were legally allowed to grow and they tried to prevent a patient from growing?
No, if a patient can legally grow and then they legalize.
But they don't let the others.
Yeah, don't let the others. Would that open up a Section 15 equality argument?
On behalf of the others?
Exactly.
I don't know. Section 15 is a very difficult section of the Charter because equality is such a circular concept where you'd have to, usually you have to show that there is a discrete and insular minority that's been discriminated against for some period of time. and so that you can then say that that discrete minority is being denied the equal protection of the law or the equal benefit of the law, without discrimination on the basis of sex, age, race, all the enumerated heads of discrimination, or other similar. I think the Charter adds a clause like that towards the end. And so it's not simply as straightforward as, okay, because you can grow, therefore I can grow. It's more complicated than that. But that would be a bit bizarre to allow medical patients to grow and not anybody else. So and I would see a challenge.
Is it safe to say that this is a historic case, and that by winning it, we're kind of paving the driveway to a more Colorado-like model that I think we could all agree is a more reasonable model for the people?
Perhaps. It's hard. It's really hard to say with all of the different emotional actions and reactions that exist out there, which are always sometimes surprising in 2014. But it's hard to say. I think that if they legalize it, people will be maybe limited in the numbers of plants that they can grow. But a lot of it will be the cities and municipalities, I think, that would have some, if not input in order for the licenses to be limited, to pass their own bylaws and stuff that would require compliance before you can, especially in the growing area. Yeah.
Excellent. Okay, well, John, just as we close out here, once again, thanks for coming on the Cannabis in Canada show and filling us in. For our viewers out there, now we've died down a bit over the summer in our fundraising. Where are we at now? I know we've raised.
I was hoping Jay was here, and I was going to get that from her, because I was talking to Tanya a bit about it as well, in terms of us. It's taking way more time than we could have ever predicted. And unfortunately taking up a lot of my time, which is expensive, instead of us having some younger lawyers running around doing the stuff that they could do. But when you're on this type of a way of doing it, you sort of want to make sure that it gets done, so you end up doing it because you're not sure you're going to have enough money to hire all the younger people. And so I can tell you that we have way more hours invested in the whole project than there is money raised or available. And I haven't billed for some time because of that. And I've been, watching it and saying, boy, don't forget, we got a 3-week trial. And if you got one lawyer at, $300, $400, $500 a day, or an hour rather, there for 5 days a week for 15 days, that adds up to a significant amount of money, not counting the preparation or the stuff at night for the next day and so on and so forth. Never mind all of these other procedures we've had to go through leading up to it. So we do need funds. The more funds we can get, the better. I know that many of the people out there are on disability pensions and so on, and that's one reason why we're trying to get them their right to grow, because we know they can't afford the LP prices and so on. So it's a tough one. So all we ask is that whenever they're able, to contribute what they can, and as much as they can whenever they can, and we'll keep doing our part. We have a substantial number of pledges from people to provide us with a percentage of whatever's recovered at the end of the privacy suit case. Interestingly, there's a lot of people who were affected by that privacy breach and wanted to move their licenses, and there are a significant number of the people who were not caught by the injunction. And so we don't know what contribution that will come from the pledges at the end. It's anybody's guess. But that's another reason for, we'll do whatever we can, try to raise as much cash as we can. We'll keep some of that cash in reserve because of expenses and making sure we get everybody we need and the experts and all the rest of it. And it may be that some of us lawyers don't get paid until after that suit gets settled and some money comes in. But, I mean, that's just the nature of the business. We're committed to seeing this through, and I've had help from Kirk Tusaw and Tanya Grace to some extent, and Matthew Jackson, and so we'll keep some of the others involved. I'm getting sort of quotes from them as to what parts that they could do and try to get them on a fixed amount. But you know, we're in it for the long haul, and we appreciate what everybody's been able to do so far. And I think it's been unfortunate that there's been, you know, misunderstandings and so on here and there, but I think overall everybody's pulled together and been trying to do the best they can in order to advance the case for essentially 40,000 people here in Canada. And I'm sure there's even more, you know, that didn't get licensed, and especially those who got covered by the injunction in terms of their personal production and everything. You know, think about some of those folks who unfortunately didn't get covered and what the consequences are to them. And I've taken the stack of pink slip off my desk, but there were nearly all people calling about some aspect of the injunction or the MMAR, and usually people who fell between the cracks. You know, people whose houses burnt down, not because of their grow, because of some other thing, and so they're stuck in hotels and they can't produce, and they need their medicine. I mean, I think that's the bottom line that people have to keep coming back to, is that this isn't about some, you know, just wanting to smoke marijuana. This is people who have been approved by their doctors for a medical purpose, and the evidence that I've seen and the stories that I've read, it's just overwhelming the help that many, many people derive from using cannabis as medicine. And the large numbers of other drugs they've been able to get off that had serious side effects. So, you know, listening to the stories and hearing how it's affected different people in different ways has really been very significant, and I hope that the courts will see it the same way.
Well, John, thank you again. Having worked on this case with you since 2012, I will see it through to the end with you, and so will the Coalition Against Repeal. Thanks again for coming on the show and clearing up many of the questions.
Okay.
I hope we can lessen some of those pink slips for you as a result of this interview. To all our listeners online, please remember, kick up the funds, come out to some of our events, you know, donate directly to Mr. Conroy or through the Coalition. At the end of the day, it all goes towards the same fight. Collectively, we can do this together. This is Jason Wilcox, and we'll see you in the next show.
And pink slips are still better than emails.
There you go.